Coach, and we are going to start today's session. So hello everybody, welcome. You have come to a Silicon Beach virtual information session, and today's session is all about how to set up your business in the correct way. Before we do get started, in the spirit of reconciliation and on behalf of the Silicon Beach community, I acknowledge the traditional custodians of the land that I'm standing on here today, which is the Boonwurrung Boonwurrung and the Wurundjeri Woi-wurrung peoples of the Eastern Kulin Nation, and I pay respect to their elders past, present and emerging, and extend that respect to all Aboriginal and Torres Strait Islander people who are joining us on the call today. I'd also like to acknowledge the sponsors of Silicon Beach who enable events just like this to happen, in particular App Demo Videos, CFO Works, Heasley Lawyers, Legally Yours and Think Innovation. So for those of you who don't know or haven't attended one of these sessions before and are wondering who I am, obviously my name is Karen Finch. I'm a non-practicing lawyer, CEO of Legally Yours, Vice President of the Australian Legal Tech Association. I'm a legal tech editor for ID Spies, a passionate ambassador of the progressive law movement and a really strong supporter of the Australian startup community, hence why I organise events like this, and I also MC the Silicon Beach virtual pitch night and in-person pitch night every month. Just a little bit of information on Legally Yours too. So Legally Yours is Australia's largest independent legal marketplace that enables everyday Australians to access quality experienced lawyers without the bill shock. We take all the confusion and difficulty in trying to find the right lawyer by matching you with vetted experienced lawyers who only offer upfront pricing on their legal services, just like we have Rahul and Anoot here. Told here. Sorry, I'm just going to mute that person. One moment. Okay. Sorry about that. So before you Google search, I need a lawyer, it'd be great if you could head to legallyyours.com.au and let us match you with the right lawyer without the bill shock, guaranteed. All right, on to our stars of today's session. We have Rahul Kumar, who is Allied Legal's Director. He's a highly experienced corporate and commercial lawyer. Rahul is passionate about adding value to clients and being regarded as a trusted advisor. He brings with him quality experience from both national and international firms. We also have Tolt. Tolt Anas is a commercial and startup lawyer with a background in media and communications. Tolt is passionate about ensuring startups are legally structured for success and loves engaging with innovative clients who are seeking to disrupt market trends. I will be putting in the chat both Rahul and Tolt's LinkedIn details so that you can connect with them, as well as Allied Legal's email address if you'd like to find out more about the legal services that they provide. So today's session, we're going to be learning all about what you need to start your business on the right foot. So from choosing the right business entity and structure to looking at how you protect your name and trademarking and intellectual property. So a little bit of housekeeping, please put your questions in the chat. We'll either answer them as we go or we'll actually, there's a slide at the end where we can actually do a Q&A at the end. And so without further ado, I'm going to mute myself, turn off my camera and hand over to the brilliant Tolt and Rahul. Thank you.
Thank you, Karen. And thank you for organising firstly, and also thank you to Silicon Beach.
Hey, what's up?
Just giving you a call.
For having us. I think there is some background if someone wants to mute themselves.
Yeah.
Sorry, Scott, if you're there, can you mute yourself, please? For some reason, we can't mute you. If everyone can please pop themselves on mute, that would be great. All right, I'll just pop him in the waiting room. No problem. Keep going.
So so thank you very much for having us today, and we look forward to presenting on setting up your startup correctly and effectively. Just a little bit about Allied Legal and our journey and what makes us tick. So we're a innovation-focused law firm, and that we help founders, entrepreneurs, and emerging businesses with their legal needs. In addition to that, a fellow director of mine, Inder Singh, also helps with the business development aspects of growing startups and helping you get to market. And that's actually quite a unique added service that we provide. So in addition to the legal, we also provide startups with helping them find channels to market and getting to market through BD services. Inder is a highly experienced sales and business development executive with expertise in IBM, leading up their Asia Pac sales team. So to have him on board with Allied Legal is fantastic. We're both very passionate about working with entrepreneurs and founders and helping their businesses grow. Tal Ernest, who's going to be presenting today's chat, is similarly passionate about working with startups, and hopefully that'll come across in the presentation today. In terms of our expertise from a legal perspective, so we help with all aspects of what we call the entrepreneurial life cycle. So that's everything from setup, which is going to be the focus of today, so helping you set up and structure up correctly, all the way through to exit. And there's obviously everything in between, and the list is there for you to see. So with that, I will pass it now on to Tald to begin today's topic. Over to you, Tald.
Thank you, Rahul, and thank you, Karen, for that introduction. So look, there's a lot to cover off when it comes to setting up your business, especially if you are a startup or an innovative business. The key issues that we're going to boil this down to for this presentation are, as is on the first slide, the key issues to consider when starting up from a legal and commercial perspective, the types of business structures available to businesses and which is the most preferred for people in the startup and the innovative space. And we'll talk a bit about business names and trademarks as well. So there are a number of key legal issues that we look at when a business, especially an innovative business, is looking to start up. The first of these, and one of the most important, is who owns the intellectual property. This is very prevalent in the startup world. So in Australia and many other countries, the intellectual property and what's known as a work automatically is owned by the person who created that. Now, that's quite simple when you're talking about something like a poem or a painting, because it automatically goes to the person who wrote the poem or painted the painting. But this can become a little bit messier when you're looking at an app, a platform, a business, new technology. And what we often see in startups is that you have a team of friends or colleagues who have all handled different aspects of creating this new contribution to the market. Maybe one person came up with the idea, you've got two people working on the code, somebody else is designing the overall user experience, and all of a sudden, it's not clear who actually owns that intellectual property. Now, the best solution to this problem is to have everybody that's worked on the product sign a deed assigning the IP into the company that is trading with that product. We're going to talk about this a little bit later on, because for this to work, there has to be a company registered, and we'll get into that when we talk about types of business structures. But for now, it's just important to know that who owns the IP should be a very important priority when you're starting a new business. Another thing that you should be thinking about is, what are the roles and responsibilities of your team members? In the startup context, a lot of work gets done on friendship or on a handshake basis. And this can be a good thing at the beginning because it keeps the relationships friendly and it keeps everybody happy to be there. However, it can be highly problematic down the line when people start having different ideas as to what they're entitled to. Let's say that you have a team of 5. Does everybody know who's a founder and who's just there helping out or consulting? Are there going to be expectations of equity or expectations of salary? While it's going to seem awkward to have these conversations early on because you want to keep things friendly, it can really help to prevent internal disputes down the line when you start generating income. And when we do see startup disputes, it almost always relates to not having these structures set out clearly early on. Now, on that note, we also ask what your startup's business model will be, and in particular, how will you engage with your clients? This is very important because it comes down to how you're going to generate revenue and making sure that that revenue generation is legally effective. You may be engaging clients through a set of standard terms and conditions. You may have a client engagement form, which both parties will negotiate and sign prior to any money changing hands, or there may be no formalized agreement whatsoever. But even if that's the case, even if there is no formalized agreement, anytime that you engage with a client, there will be a legal relationship that exists between you and them. And it's really important that you understand your obligations under this legal relationship, especially when it comes to preventing disputes, payment disputes, product disputes down the line. It's also really important to know whether any industry-specific laws or regulations apply to your business. So for example, the Privacy Act, which is something which pretty much anybody that's in the innovative space should be thinking about, it only applies to small businesses if they fit certain criteria, such as health businesses or credit reporting agencies. Or if you're in the education sector, you might need to be aware of your working with children requirements and make sure that you've complied with those requirements. It's very important to map out what the regulatory framework that applies to your business is as early as possible. That way you can ensure that you're compliant from day one. And it's also really good to be aware of what grants or government concessions that your business might be eligible for. There are a lot of grants available to startups in Australia, and they are subject to all sorts of deadlines and criteria. Knowing what grants that you may be eligible for ahead of time can ensure that you set yourself up in such a way to meet the criteria and put yourself in the best position possible to receive that grant. And Rahul, if you can go to the next stage, the next slide, sorry. Now, the very obvious initial consideration that I haven't touched on yet is how you will be structuring your business. And that will be the bulk of what we're presenting on today. Now, the four most common business structures available are sole traders, partnerships, trusts, and companies. I'm going to talk across all of these, but I will say at the outset that a company is the preferred structure for a startup. One of the reasons being that it protects the personal liability of its directors and its shareholders. But I'll get to that in a bit more detail. First, I want to talk through the other three. So a sole trader is a type of business structure where you as an individual are the business. A sole trader is normally okay in the early phase, and until you do register your company, by default, you'll probably be operating as a sole trader. That being said, it's never really appropriate to continue operating as a sole trader when there's any level of risk being incurred. This is because sole traders are personally liable for any debts of their businesses. That means that debts can be applied against your personal assets, such as your house or your car. Now, obviously, you don't want a creditor coming after your personal property if you can avoid that. Similarly, in a partnership, the individuals of the partnership also make up the business. A partnership arises where two or more people combine their resources and expertise to operate a business as partners. These are most common among service professionals such as accountants and lawyers and accounting firms and law firms. But a big problem with partnerships is that the partners are liable for each other's debts and liabilities. So typically, professional firms will enter into what's called a limited liability partnership, which protects one partner from being liable for another partner's business debts. But even then, it doesn't protect their own personal liability from any debts that they incur. So that means that, again, a creditor could come after their personal house or their personal car. Now, a trust is a bit different. A trust is a type of business in which a person or a company called the trustee manages assets on behalf of beneficiaries. This isn't too different from a business and shareholders conceptually. But in this instance, the role of the trustee is to generate income for the trust using the trust assets, which is then distributed to the beneficiaries. There are different types of trusts, but the most common that we see are discretionary trusts, which are sometimes referred to as family trusts or unit trusts. In a discretionary trust, the trustee can pay income to the beneficiary at the trustee's discretion, hence the name. In a unit trust, the beneficiaries are unit holders, which are akin to shareholders, and they're entitled to be distributed income of the trust on a fixed basis. Now, because the purpose of a trust is to hold an asset and generate income using that asset, trusts are often used for things like property investment businesses or as a means to hold assets for tax planning purposes. While we don't recommend in most situations running your startup as a trust, when it comes to owning shares in your company, it can be beneficial to establish a trust to hold those shares for tax purposes. Now, as I said before, the one that we usually recommend for most startups and individual businesses is an incorporated company. When you register a company, you are in fact creating a new entity at law, which is made up of shares. A company is treated as a person. It can enter contracts, it can own property, it can sue, it can be sued. And this structure yields a lot of benefits for startups. First of all, like I mentioned earlier on, it provides a mechanism for you to house and protect your assets, including your intellectual property. So, like I said before at the beginning, you want to protect your IP, and a way to do this is by executing a deed assigning IP into the company. For a startup, your intellectual property is usually your most important asset. So by assigning that intellectual property away from the people who created it and into the company that now wants to control it and trade with it, you can demonstrate to investors and other stakeholders that the company actually owns with certainty its most important asset.
Can I just interject there, Talt, just for a sec?
by all means.
So just so we're clear, the point we're trying to make is that in the startup context in particular, what tends to happen is you have a bunch of people that come together and they just start working on an idea. In doing so, and Talt has touched upon this, in doing so, what you're doing is you might be inadvertently creating IP, intellectual property, through the venture you're working in, right? And that could be by way of, you might be developing some code, you might be developing a platform, it might just be know-how, it might be logos for a business, whatever it may be, that all might be, all such activities may be getting done informally. So the point there is, while all such activities are great, everyone who's worked on the venture in their personal capacity owns that IP themselves, and so there's normally a little bit of a time lag between those activities occurring and the company being registered. And that's why once a company is registered, what we would normally do is enter into a deed of assignment between each of the individuals, or founders as we call them in the startup landscape, between them and the company, to assign all their intellectual property rights to the company. To the extent that you are registering a company prior to any such activities occurring, obviously it makes the deed of assignment redundant. I'll let you continue, Talt.
Yeah, absolutely. And you know, in saying that, it's there is a question of, which we'll touch on more later, when you do incorporate your company, but for this purpose, the earlier that you do it, the better, because it means that that IP is more likely to be protected from earlier on than later on. Now, another benefit to having a company is that it enables your business to raise funds by onboarding investors. So like I said before, a company is made up of shares, and each share represents a percentage of the company. Each owner of a share is entitled to a proportionate amount of the company income based on what percentage of the company they own. Now, if you're a sole trader, or if you're a partnership and the business is made up of you as an individual, there's no way for you to sell percentages of yourself to different stakeholders. And so there's no way to really onboard investors other than bringing on loans, which creates debts, which you often want to avoid. If you have a company, you can issue shares, which are parcels of your companies, to investors, which isn't only a good means for raising funds and bringing on capital, it's also a good way to create strategic relationships. We won't go too far into the benefits of investment and how to navigate that area, because that's not the purpose of this presentation, but it's safe to say that almost all startups will look for investment at some point. Going back to the IP issue, if you are looking to bring an investor into your startup, they're almost certainly going to want to see some sort of proof that the IP in your startup is in fact owned by your company. Like I said, it's the most valuable asset that your company owns, especially earlier on. An investor isn't going to want to invest in a company that doesn't have certainty of ownership of that intellectual property. Now, one of the most important features of a company is that it also limits your personal financial liability to the amount that you have invested in the company. When you register a company, you benefit from something called the corporate veil. This is effectively a partition or separation between your liability as a shareholder and the company's liability as its own individual entity. That means that the company can go and incur debts, it can take on loans, and if the company down the line is unable to pay those debts or those loans, your personal liability as a shareholder is protected from that.
That is obviously subject to any personal guarantees you might be entering into, which can often be the case in the case of loan arrangements. So personal guarantees, personal guarantees make the shareholder who's entered into that personal guarantee, or director, personally liable for the debts of the company.
That's correct. Yep. And it also is limited to so long as the shareholder or director has not acted illegally or fraudulently or engaged in misconduct. As soon as those lines are crossed, then a director or a shareholder can become liable for its company. But assuming that everybody here is honest people with no intention of breaking the law or acting fraudulently, that's not something which you need to worry about. That being said, you should be aware of your responsibilities as a director or a shareholder under the Corporations Act. They are fairly prescriptive. But But ultimately, this corporate veil, as I refer to it, means that if the company goes into debt, which you can't pay, then your personal assets, your house, your car, your TV, those will be protected as long as you're not a guarantor, like Rahul pointed out before. Another benefit to having a company structure is that it allows you to bring in employees or build your team on equity incentive arrangements, for example, ESOPs. This allows for more creative and flexible mechanisms to build your team than other arrangements like sole traders and partnerships. Now, I touched on before as well that when you are setting up your startup, you want to be aware of the types of grants that are available to your startup moving forward. Now, the benefit to having a company is that it will usually make you more eligible for these grants or make it easier for you to apply for these grants. Most of the grants are only available for companies, and even when they're not just available for companies, you'll usually be better off applying for a grant as a company than as a sole trader or as a partner, simply because of the way that they're structured. Some grants, like for example, the R&D incentive, applies as a tax write-off retrospectively to money already spent. So if you have set your company up early and you start spending money on research and development of your product as that company, that puts you in a good position to claim the R&D incentive down the line when it's getting to tax time, and you can start claiming those write-offs. Now, a question that a lot of people ask us is, when is the best time to be setting up their company? The simple answer to this is as soon as possible. The earlier you do it, the more likely all of these things that we've discussed are going to be checked off. Your IP is going to be protected. Any debt that you incur in the early stages of your business will be separate from your own personal liability. And there isn't really any downside to incorporating your company earlier in the process. Now, if for whatever reason you don't want to take that step earlier on, and you want to be thinking about what's the absolute latest that you can be incorporating your company, well, it should be incorporated prior to taking on any risk, incurring any debts, or generating any revenue. If you are looking at fundraising and bringing on investors, then you certainly want to have a company incorporated before you start looking at that. And if you're going to be building your team, you know, hiring any employees or contractors, even software developers to develop your products, you want to have your company registered before then to be entering into those contracts. Like I said before, a company as a person can enter into contracts, and then that way the obligation to pay that contractor is on the company and not you as an individual. So if you're looking at the latest possible time to do it, it's before any risk, any debt, or any revenue starts being generated.
I would actually go further to say it should be earlier than that, because obviously revenue can be quite a milestone in the startup context. As a general rule of thumb, once you're beyond ideation, so it's more than just a thought bubble, and you're looking to spend some time and effort into this, even if it's as a side hustle with your current employment. That's probably the right time to start thinking about registering a company. I mean, the main downside is the registration fee, which is about $500, and there are certain ongoing ASIC requirements, and obviously there is the directors' duties that come under the Corporations Act, but ultimately all of that is far outweighed by the benefits Talt has touched upon. Shall I move the slide forward now, Talt?
Yeah, go for it. Actually, Rahul, I think we jumped the gun there. Just a few things to talk about. This is a dual company structure, which we'll talk about in a bit because it's quite a interesting and creative way to set up a company. I did just want to talk about the way that you can register your company if it's something that you're thinking of doing. So look, effectively, anybody can register their own company through ASIC. Like Rahul mentioned, there's about approximately $500 fee associated with registering that company. And there are websites. One example is eCompanies, which offer a user-friendly company incorporation service to make things much easier for you. Now, that being said, if it is an option, we do always recommend engaging the assistance of a lawyer or an accountant to set up your company. There are a number of reasons for this, one of which is that they can help you structure your company, distribute your shares and your shareholding at first instance in the best possible way. They'll be able to advise you ahead of time on what your tax and other legal obligations are under the Corporations Act and under tax law. So if it is an option to bring on the assistance of a lawyer or an accountant, it's always the best bet to do that, because not only will they help you maximize the benefit that you'll reap from having a company, they'll also help you prevent any risks or liabilities down the line from doing things wrong. And in terms of downsides, like Rahul mentioned, they are pretty limited compared to the benefits, as well as the ASIC fee and the director's duties under the Corporations Act. The only other thing that you really have to think about is that a company has to have its own tax return filed each financial year. And this may lead to somewhat more paperwork and accounting fees than other models. But ultimately, these are pretty low cons to all of the positives that you receive. Now, the dual company structure is one structure that we recommend to startups in particular that have IP. The way that it works is that you incorporate two companies to run your business. One is the holding company, which we refer to aptly as Holdco on the screen, and the other is the operating or trading company, which is Operating Co. The holding company will typically hold all of the shares in the operating company, as well as any intellectual property and material assets, but it will conduct its business through the operating company. What that allows is for the operating company to enter into contracts, incur debts and liabilities, take on all the material risk without putting the company assets at risk, because those are held by the holding company. Rahul, did you want to expand further on the dual company structure?
Yeah, so this is something we recommend as and when you are looking to start engaging in activities with externals, right? So where you might be looking to enter into contracts or hire people and the like, it's not something you have to do right away, because we appreciate that funding can be is an issue in the startup context, but certainly as our clients begin to scale, and we always we always ask them to keep the structure in mind so that it can be put in place prior to them entering into any significant arrangements. It's a pretty clean way of protecting your the material assets in the parent company up top there.
Yeah.
Shall I switch
move
over?
Yep, move on to the next one. So now we're going to talk a bit as well about the key early stage documents, which don't just relate to registering a company, but just sort of documents that you should be thinking about in the early stages of your business. So the first one, the deed assigning intellectual property, I think we've discussed this in a good amount of detail now. And if you have any further questions on that, we can get to that in the Q&A portion at the end, or feel free to leave them in the chat, as Karen pointed out before. Another document to be aware of is the company constitution. So this is a corporate governance document, and it's automatically generated when you register your company. It sets out what's called the replaceable rules to govern a company under the Corporations Act.
Can I just interject there? So the Constitution is should be something that is issued as part of registration. If it's not issued, it will be your Constitution will be set out in the Corporations Act under what is called the replaceable rules. And so whether you have a formal constitution or not, whether you're aware of it or not, there is your company will always have a constitutional framework under the Corporations Act. Do you want to move on to the shareholders agreement then?
Yeah, for sure. So the shareholders agreement is a bit more specific than the Constitution, and it has the opportunity to be far more bespoke and tailored than the Constitution. So, and I'll just say we draft shareholder agreements very frequently. They're a very common and essential document for a company to have, as it effectively sets out the relationship between the shareholders and each other, between the shareholders and directors, and between the shareholders, the directors, and the company. The sort of rights, obligations, and responsibilities that it sets out include, by way of example, the voting rights and powers of the shareholders and the directors. So under the default rules, most decisions for a company only require a vote of at least 50% of the shareholders or directors, which is referred to as an ordinary resolution. This means that if you're in a situation where you hold 50% or less of the shares, decisions can be made without your approval. Now, a shareholders agreement can replace this rule. Usually, it will set out a regime of decisions, some which require 50%, some which require 75%, or some which require a unanimous vote. But those proportions aren't set in stone. They can be changed in the shareholders agreement. So for example, you could have it that an ordinary resolution requires 66% of the votes, or any other percentage really that suits your purposes.
I guess if so the point there is that without getting in sort of into the complexities of what a shareholders agreement would normally set out, what you should keep in mind is that it's a document that allows you to you and your founders to essentially decide how you want your company to be governed and how to, and managed moving forward. So you know, you can personalize it, so to speak. And especially in the startup context, again, where different people bring different things. For example, someone might have be financially contributing, others might be contributing through their skills, such as you know, they may be very proficient in coding or a specific industry expertise. When you're bringing different valuable resources such as that, you might, irrespective of the shareholdings, the shares that you hold in the company, you still might want decisions to be made unanimously, for example. And all such issues are set out in the shareholders agreement, among others. But that's why we normally recommend that it's a document put in at the early phase. Over to you, Tyler.
Yeah, absolutely. I mean, for example, I was talking with a client recently, and they kept on, this was in the early stages of preparing their shareholders agreement, and they kept on throwing around a term, which was, you know, they kept on saying standard shareholders agreement, standard shareholders agreement. And I had to point out to them that in the startup context, there is really no such thing as a standard shareholders agreement. You have certain terms which don't tend to change that much from case to case, but most startups have very unique and bespoke arrangements that they want. And shareholder agreements can be quite creative and flexible to suit those needs, which, you know, can be much more flexible than what the default rules are under the Corporations Act. And it's good to have this put in writing early on. Especially, I mean, as soon as you register your company and you're distributing your shares, you want you and every other party to be aware of what their rights, responsibilities, duties, and obligations are to each other and to the company. It also comes in useful when you start bringing on investors. If you already have a well-written shareholders agreement in place that you can give to the investors to look at before they come on board or when they come on board, it prevents a situation from where there's ambiguity and a lack of clarity around who has what sort of power and what sort of obligations. I might move on to employment agreements and contractors agreements, Rahul, unless you wanted to add anything over and above to shareholders agreements.
No, not really. Even on the employment and contractors, I think we can be fairly high level, but it's obviously how we engage. But I'll let you go. You go for it.
Yeah, absolutely. So so this is a fun one for me because we've recently just been involved in quite a lengthy litigation where a big part of it was whether the person involved was an employee or a contractor. And it's very important that everybody involved knows whether they're an employee or a contractor at the beginning. I won't go into the details of what those differences are, but effectively, employees have certain rights under the Fair Work Act, that contractors don't have, and contractors have other rights. It's fine if you want to bring people on as employees, and it's fine if you want to bring people on as contractors. Both are perfectly effective engagements, but have their own, you know, pros and cons. But it is very important that you have these agreements in place at the outset as soon as you start bringing talent into your business. It gives clarity as to what their role is. It gives clarity as to what their entitlements are. And it removes the risk, or at least it limits the risk of them bringing any payment dispute or salary dispute or saying that they were entitled to something which they haven't been given. So this is a fairly high level summary of the very early stage agreements that you should be turning your attention to at the very beginning. Anything further to add there, Rahul?
Yeah, the only other thing I would mention is a couple of documents that are not there. Tal touched upon in terms of when we assist with company incorporation, we normally do place a little bit of time on tax planning, and as part of that, you may hold your shares in the company by way of a discretionary trust, and so that's the way that's affected is usually through a trust deed. So that's something that, in terms of early stage documents, you might see. The other part of in the startup context, obviously, any again with funding being at being scarce, you're likely to be incentivizing people to join you on your journey through equity arrangements. So that can be done through employee incentive schemes or share vesting arrangements that that you might also see in the early stage of setting up the business structure.
So we'll touch on as well a bit on business names, company names, and trademarks. So starting with the fundamentals difference between a company name and a business name. A company name is obviously the name of the company that you register. It's almost always a PTY LTD or a proprietary limited company name. A business name doesn't require a company to exist, and it has an ABN, which is your Australian business number. A sole trader can have a business name, or a partnership can have a business name. And a company can have a trading name, which is separate to its company name. So you might see on documents, for example, company X PTY Ltd trading as company Y PTY Ltd. That's completely fine. You might want to go to market with a different name than the name under which your company is registered. Now, if you're operating under a business name that you haven't yet incorporated a company, you can register that name on ASIC prior to incorporating your company. And that can be beneficial because it gives you some security around that name when you actually get to the point of registration. So if you haven't registered your company yet, but you do have a business name that you have in mind, whether or not you're already trading, we recommend going on ASIC and registering that business name. That way it's held for you, it's secure, and when you get to incorporation, you can rely on that name. Rahul, did you want to add to that?
Yeah, just a small point of clarification. So when you register your company, you're issued with an Australian company number. As in when you, there's an additional step, as in when you register that company with the ATO for tax purposes, the ATO then issues you with what's called an ABN, an Australian business number, and that triggers your requirements to lodge BAS statements and the like. But we won't get into that. So they're two separate issues. You have the Australian company number versus the Australian business number. But go for it.
And I will just point out as well that I did mention before that there's no reason why any person can't go ahead and register their own company, but these sort of questions are why it becomes helpful to have your lawyer or your accountant on board. So, for example, the difference between when do you have your ACN, when do you have your ABN, when do you need to register that? That's something which an accountant or a lawyer can help you with to make sure that you are compliant with your tax and corporation law requirements along the way. Now, a trademark is rather different to a business name. It's usually something visual, a symbol, a logo, a phrase, a collection of words that distinguishes your business. Coca-Cola is a trademark. The Apple symbol with the bite missing is a trademark. The kangaroo on Qantas, those are all trademarks, which are a separate thing to the company name or business names of those companies. Now, registering your trademark through IP Australia, it prevents other entities from using that same or similar name for their business or that same or similar look for their business. This is really important when it comes to protecting your recognizability or uniqueness or just general brand image in the market. It is a bit different to just copyright, which exists at law, because a trademark you actually register through the trademark register. It lasts for a period of about 10 or 12 years, depending on the type of trademark. And it needs to be used for that registration to survive and for those protections to survive. So if the name that you're trading with is a fairly unique name, if you have a fairly unique logo that you want to identify your business by, it's not a bad idea to go ahead and register that as a trademark to protect your market position and your market recognizability. And I'll talk a little bit about just general concepts and ideas and basics around intellectual property. Unless Rahul, you wanted to just add to the trademark conversation.
Yeah, look, again, we take a fairly commercial approach in assisting clients in the startup context. Trademarks and registering them, we're covering it off because it obviously it all falls within the ambit of setting up. But look, the fact of the matter is, unless you've got, for example, we're working with a client that's producing food and drinks which are really healthy for kids, and they are a big part of their overall business planning and business scaling is relying on the images and the logos and things that they're creating. So in that case, registering trademarks is very important. Whereas generally speaking, 9 times out of 10 in the startup context, it's something that we don't see as much. People are normally, you register your business and then you get on cracking on with the with developing your platform or whatever it may be that you're working on.
Yep. And yep. And just before we hop onto the Q&A, because we do want to leave a good 15 minutes or so for you guys to ask your questions. It is always just important to cover off some things in intellectual property, it being such an important element of innovative businesses. So there are a couple of steps that you can take to protect that over and above the deed assigning it into the company. You can consider having and maintaining an intellectual property register, which clearly sets out and identifies the intellectual property that relates to your startup or your business. As we discussed, you can structure your business, for example, using that dual company structure to protect your IP. Your terms and conditions or your client agreements that you set out should always contain robust clauses, making it very clear that just because someone is being licensed to use your software, your technology, doesn't mean that they have any rights in that technology. It's really important to secure your IP when you're working with third parties to develop your IP. So a trend that we've been seeing lately in development agreements is that the developers often try to retain a significant portion of the IP that they're being paid to develop. If those agreements aren't ironed out properly, then again, that can cause uncertainty as to how secure your IP actually is. As we mentioned before, if you have started generating IP before your company is registered, make sure that it's assigned, but even better, register your company early. That way there's no question about who owns it. And anytime that you're using third-party IP, if you're using a third-party IP to develop your product or your technology, make sure that you're aware of their terms and conditions. Make sure that you're aware of how much of a hold they have on that final product so that you know how to navigate that situation. And look, like we said before, that's not the overall purpose of this presentation. This is more about structuring and early considerations. But just because we are in the innovative space, it is a very important topic to close off on. So with that, I'll pass it back to Rahul, or I'll pass it to everybody listening to go ahead and ask any questions. You can unmute yourself or drop your question in the chat. That's up to you.
Thank you. What I might actually do, Todd, while people are putting questions in, I might actually end the recording and that way then people can turn their camera on if they'd like to ask. So I'll officially end proceedings for this recorded component. So thank you so much to the both of you. That was fantastic and so much incredible, insightful and valuable information in there. I will be sending this recording link to all that have attended as well, because sometimes with legal information, you need to watch it again in order to digest it a little bit easier. But thank you you so much. As I've put in the chat, please reach out to Tolt and Rahul on LinkedIn. You can go to Allied Legal as well at .com.au, or you can actually find Rahul. You'll find him on our platform as well if you wanted to connect through legallyyours.com.au. Look out for more Silicon Beach events coming through on your meetups, and we hope to see you there at the Silicon Beach Pitch Night, which is coming up on the 3rd of June, which will be a virtual one. I'll end the recording there and we'll get to those questions. Thanks so much.